For joining, and please enjoy the webinar. Over to you, Howard and Rowana. Thank you so much.
Oh, great, Debbie. Thank you very much. And Rowana, I feel like I'm meeting you via different people. First of all, Debbie's been talking about you a lot, and Remco spoke about you a lot. So it's really nice to get to see you and listen to your presentation. So I don't have much more other than to say that you come highly recommended, certainly firstly by Remco and secondly by Debbie. So look forward to the discussion. Thank you.
Yeah. Well, thank you for the warm welcome. And yeah, it's really nice to meet you finally, because I've heard all about you as well. So yeah, I'm going to start my presentation. I'm going to introduce myself because I'm new into this group. So let me start sharing my screen first. So my name is Rowana. I am a data privacy officer and compliance officer in the Netherlands in the automotive industry for nearly 4 years right now. And before that, 6 years in a health insurance company, also in the same role. And there I started with implementing a process on data breaches, and now it's all about AI. So implementing an AI framework, evaluating AI tools. So yeah, and today I want to share my experience with you and give you some practical tips to keep in mind when you work with AI. So on today's agenda, I start with the GDPR, data privacy regulation in the EU. The definition, because all the important aspects of the definition of personal data, everything around data processing, the roles which are defined in GDPR, and the principles relating to the processing, and these principles are also reflected more and the same in the AI Act. So I make a bridge towards the other law. The AI Act, also European law, and I will discuss the origins and the important points of the key points of the AI Act. The principles and the roles, and very important, the risk level. So if you work with AI, you must make sure that your AI system has a certain risk level. And at the last topic now is covering ethics. I will dive into that very briefly, how you cover ethics and avoid AI risks. And then at the end, a brief summary. And if there are any questions, I don't see them, just so if someone wants to warn me, it would be great.
Sure. Howard or myself will warn you if there are any questions. And are you happy if people raise their hands and ask questions during your presentation?
Sure. Yeah, that's perfect. Yeah.
Perfect.
I like some interaction because now I'm looking towards a large screen, so I don't see much, but yeah.
Yeah,
we
got you.
Thanks. So the basics of the GDPR. It's good to know that personal data under the EU GDPR is actually any information, so it's a very broad scope, that leads to the identification of a natural person. And it can be directly leading towards an individual or indirect. So here you see some examples, like a surname. Yeah, that's obviously a very a direct personal data. And like the online ID can be an indirect identifiable personal data. Data processing, also good to know. Under the GDPR, it's also very broad, but it's everything that you can do with personal data, from collecting, storing, deleting, forwarding via email, etc., etc. And And here I mentioned the roles in the GDPR because it is important to know that if you process personal data, you need to know which role you have. So are you responsible for collecting the data? So here in this example, we see that I use a startup. Now, of course, it wants to sell its product, and therefore it needs a postal address because otherwise we cannot send the product to the customers. So it, as a controller, the startup determines the purpose, so to send this product for marketing purposes, and the means, and that means that how they want to do it. They want to store it via tooling. And then I come to the second role. It's the data processor. It's most often a supplier who processes personal data on behalf of the data controller. And here you see the software supplier, which offers the tool, for example, if the customer relations management system that the startup wants to use, or the HR software that the startup wants to use. And of course, in the law, it's also defined the data subject, the individual from whose the data is collected. And one of the basics of the GDPR is that you need to have a legal ground to process personal data. Otherwise, you cannot simply do it. You can process the data if someone gives you consent. So it gives you their information and says and confirms that you can process it. Of course, if for the performance of a contract, you need personal data, like I mentioned in my example before. You need a postal address or an email address to send your white paper or whatsoever. There are legal obligations under which you can process data. And like I said, 6 in total. And the other important one is relevant for our business is the legitimate interest. The data controller can have an interest that is more important than that of the individual, and I will discuss that later when I discuss the topic of AI. These are the principles you have to keep in mind while processing personal data. It must be lawful, you must be fair and transparent about it, so the data subject must know that I process the personal data. So let's say I want to have the name and the email address of Debbie. To send her an email or to send her any information, it's fair for her to know that I have her email address and I'm going to do that. Purpose limitation. So you need to have a specific purpose to process personal data and a legitimate purpose, like I mentioned in the slide before. And you can only process data that you need and not more than that. The data must be accurate, and it must also be the data subject. For example, Debbie must also have the ability to correct her data if I process it wrongly. So for a good example, Debbie, I just saw it, but my last name is Santoso and not Santosa. So I'm under the GDPR, I have the right to tell you, hey, please correct it because it is wrongly reflected right now. That is an example that I want to, makes more sense maybe for you.
My apologies.
No worries, but I saw it and I was just like, oh yeah, this is a perfect example of accuracy.
Nice,
principle.
there we go.
Yeah. Storage limitation, you can only store it for the time you need, and as long as the law says. So sometimes the personal data or the purpose that you store the data is covered by a law, and it says like, okay, for example, in the Netherlands, you can only store applicant data for a very short time and not for 5 years. And under tax law, it's maximum of 7 years. So you cannot store it for 10 years, no, only 7 years, and then afterwards you need to destroy it. After those 7 years, you need to destroy it, delete it. And integrity and confidentiality is all about security of the data. I see a hand of Howard.
Hi, Rowana.
Hi.
There is a question from Adam.
Okay.
I'm not sure if it's part of the principles, but his question is, what about the requirement of a DPO, a data protection officer, as a specific or individual role? I'm assuming is that not really a principle, but more of a requirement?
Now, it's a requirement depending on the situation. So if the company processes large amounts of data or sensitive data, it's defined by the GDPR when you need to have a DPO. Is that answering the question?
Okay, great.
So yes, the role of the DPO is also important. It could be mentioned here, but it's depending on the situation of the organization. So if it's a large company, it's mostly likely that you process huge amounts of data, of personal data, and then it's most likely that you definitely need a DPO in the organization. Yeah.
And then maybe a question from my side. A lot of the times GDPR is also related to ethics, and sometimes I get confused in terms of a lot of the times people refer to ethics as something that's not legal, but so it sits outside of the legal realm, and so I don't see any, other than fairness, maybe I don't see any ethical principles here. So is there a confusion as to this ethical role within GDPR?
No, it's not so. It's not so clear as in the AI Act. I can
definitely
confirm that. Yeah. So, that's a good question, Howard. But I think it's now more reflected in the AI Act and better reflected. And I will jump into that later. But it could be better under this. But it's all. The GDPR is more about giving individuals the right and the control of it. So that's more the aim and the focus of the GDPR, and where it's more in the AI Act. And before I introduce everything of the AI, but
no problem.
ethics is more covered in the. It's more part of the AI Act right now. Yeah.
Thank you.
Instead of the GDPR. That's correct. Yes. All right. Two important principles that you need to be aware of is the accountability. It's basically the responsibility of the data controller to be able to demonstrate what they do, how they do, when they process personal data. So
let me see.
Is there someone?
I'm looking now. Mayela, we're muting her now.
Okay, thanks, Debs.
Yeah.
No worries.
Okay.
And so the data controller must reflect, must be able to reflect what they do with the data. And like, for example, if the supervisor is coming and do a research, I have to be able to show my register of processing activities in which personal data is reflected. If we have performed any data privacy impact assessments, where you evaluate the high risk of the data processing. For example, what also fairly new is the overview of third parties. It shouldn't be new, but it has drawn more attention now with the DORA legislation, the Digital Operational Resilience Act. So you need to have an overview of your third parties. You need to know if they're critical or not for your service. And this also has a similar under the GDPR. You must know where your data goes and where your data flows. And also part of the accountability is also the DPAs, the data processing agreements that you have with your suppliers, and the technical organizational measures that are in place to protect the personal data. Take the data with them and to another company, have the right to object and to automated decision making and profiling. And I mention this because it's also relevant for the AI Act, which I now jump into. Are there any questions so far that I missed?
That's it.
Good. To give you some background.
I was going to say to the Rowana.
Yeah.
I was going to ask it in the chat, but I'll just since you asked,
No,
I'll
perfect.
ask it verbally. Is there not also a time frame within which a company has to provide that information to the data subject?
Exactly. Yes. Under the GDPR, you must provide it within 30 days, unless you're not able to do so. But then you have to make notice, and then you have to inform the data subject that you need more time. So sometimes it's an investigation needs more time, and you are dependent on different departments and different colleagues. So it can, if you want to do a proper research and handle the request properly, you can do that for a little bit more than 30 days. Yes, that's the time frame.
Yeah, that's what I thought. Thank you.
You're welcome. So the AI Act, it is part of the European Commission's Digital Decade campaign, in which the European Commission is focusing on digitalization for until 2030. And the AI Act is the first of laws that has been launched regarding AI. So here you see three laws that are relevant and covering AI. And for your understanding, today I will only focus on the AI Act, the first one. It has a risk-based approach, and it's all about product regulation. And it is about supporting innovation, but also protecting fundamental rights. The second one, I jump briefly into that, is that the AI Liability Directive. It's a framework for liability, all related to AI systems. I marked it red because it's just due to political influences, which has recently been shown. It is withdrawn by the European Commission, so therefore I marked it red. It's currently not active. It's withdrawn because it has a lot of holdback and a lot of discussions from the USA. Because in the USA they think the Prime Minister thinks that is of the Vice Prime Minister thinks that it's not fostering and promoting innovation at all if you establish a framework for liability. So that is basically why it's withdrawn, and there's a lot of discussion with it in the EU. So that's set and that's withdrawn. And there is a product liability directive. So it's a new review of existing product liability rules, and it now includes AI and automated systems.
I see Adam's hand is up. Adam?
Yeah, I just wanted to note that, I'm personally very ticked with the U.S. that they can't get their act together on this. I may disagree with a lot of EU regulations and over regulations as I see them, since I deal with regulatory and compliance. But I think the GDPR and AI, they are the areas that the EU is leading in, and I fully support the AI liability. I think there should be. Obviously, I think there needs to be a lot of discussion around the nuances of it. But look how long it took to get for just the bare bones of GDPR itself to get up and running. What, 5 years before you had to get it from when you were notified, before you had to get it implemented, and then it's changed so many times since then. So yeah, I wish we would get it. It's like, just, hey, the framework's already there. Why reinvent the wheel?
Exactly, but yeah.
And we've got our competing rules. Different states have their different laws, which is, to me, it's just stupid, and it makes things so much
complex.
Oh,
I think
ridiculously.
Yeah.
Thank you.
I'm really happy that I just focus on the EU, but not on the USA law, because it's so divided and so much more.
Yeah, you see, I try to focus on both because I deal with a lot of international companies.
Mm-hmm. It's interesting field that you're working in. Thank you.
I'm kind of a unicorn.
All right. I just want to jump into I think maybe for you, fairly familiar, but the definition of an AI system is machine-based, is operated with different levels of autonomy, including a human in the loop or not, for explicit purposes, shows ability, adaptability, can generate outputs, and can affect physical or virtual environments. And I think the streaming services you probably all are aware of are a perfect example of this. And the AI Act, I've mentioned it already, but needs to make sure that AI systems are safe and to protect fundamental rights. It must be transparent that, it's an AI system that you are talking to or working with, etc., or process your data. And it must be preventing harmful outcomes. And it targets specific rules for AI systems, high-risk models, but also prohibited models, the ChatGPTs, etc. And it's applicable in every EU member state and non-EU if AI activity it takes place in the EU market.
So, Rowana, just a quick question on my side. If you can, you're going back. Is it a requirement that AI systems must be clearly AI systems and not people?
Yeah, well, it depends. A good question, but it depends on the AI system and the risk level. And I will, if you can hold that question, and I will jump to it in a few slides. Yeah.
Cool.
Thank you. I mentioned it. I reflect here all the principles that I think that are in the AI Act, and I use the same symbols, but you can see already a lot of topics principles are the same as in the GDPR, or mentioned differently but are similar. Trustworthy and transparency. You must, like I mentioned just before, it must be transparent that it's an AI system, that is your data is processed via AI, and the system must be trustworthy, because we don't want harmful output. An intended purpose. So if you are developing an AI system, when you start, you have a purpose, and you have to keep that purpose in mind, and the AI system needs to work accordingly and have the same purpose. Accountability is actually the same as under the GDPR, but not the same reflected in the law. But someone must be accountable for the AI system. And I will show you later which rules are relevant for this principle. I marked it here. AI literacy is an obligation of all companies who work with AI, as from the 2nd of February of this year. All companies who work with AI should be should train their employees or everyone who works with AI, so they must be able to detect and see the risk that AI involves. And this one is it's an important principle on which we work on right now. And accuracy, it's the same. You want as under the GDPR, you want the system to be accurate and give the desired outcome. Storage limitation is not as clearly reflected under the GDPR, but the data and the data sets of the AI must be stored for a limited purpose, of a limited time. And the same security principles. The AI system must be robust. It must be secure, safe, and protected from all cyber threats. And here again, the rights of individuals, because if it's fully automated, it's still the individual must have the ability to object to the automated decision making or their profiling. So it's, if you implement AI, you keep always the rights of individuals in mind. The AI Act introduces more rules than the GDPR, but they are slightly different. So the providers, we have deployers, importers, distributors, and of course the users, the affected persons. And so when you implement an AI solution, firstly think of your role. Are you a provider? Are you a deployer? Do you provide only the AI tooling? Then you have a lot of responsibility. And secondly, which AI risk level applies? And then I will jump into that later. But depending on the role in this chain and the AI risk level, the various obligations apply. So if you are a provider, and depending on the risk system of risk level, you can have the obligation to maintain and just keep the AI system and the software and the logging all up to date, and inform all your customers who use your AI product. And I will mention it later, but there's a lot of obligations depending on the role that you have. And now I jump into the question of I don't know who it was again.
William,
but,
I think it was William.
Yeah. So depending on the AI system, you have certain transparency rules. Yes. So the first one, under the AI Act, there are here the four risk levels defined. The first one is the unacceptable risk. So those AI systems are forbidden. And I'm here in the example, it's an image that I found, is that social scoring is a perfect example. It happens in China, and it is based on, depending on your behavior or data of depending on your behavior, you can get a finance or not, or you get points. And this is for in the EU is really not allowed. So I'm basically in my job, I only see the high risk ones or the limited risk ones, and the AI systems where you need to show that it's you need to show that it's AI, and so we are talking about the transparency obligations, the AI systems with limited risks for the individual involved. And the high risk AI systems are the systems that can cause harm and have an impact on the individual. So for example, there are already laws for airplanes or elevators and the manufacturing of it. And so these are already in the list in the AI Act. And these are high-risk AI systems. If you want to develop an AI that processes data for here it's in education or in employment. So if you want to use an AI system that can screen new applicants, you must make sure that every aspect of the AI Act is covered, because if it's covering employment at work, and it's already identified as a high risk under the AI Act. And then you have to meet certain, you have to comply to a lot of regulations, like, and also document a lot of all your processes and all the things around AI. And it's less if it's not that impactful, and it's you only, for example, if you use a chatbot and in your company, which provides information on policies that you have in the company. It must be clear that it's a chatbot that you're talking to, and that's not a human, and then you're basically fine. So depending on the use of the purpose of your AI system, the obligations arise. I see Howard.
Yes, Rowana, I'm not sure if you've read about the NIST AI risk management framework. They have that functions and processes of govern, manage, map, and monitor. I don't know if you've compared that to the EU AI Act.
No, I've heard about it, but I didn't compare it yet. No,
Okay.
I haven't compared it. No, sorry.
Because a lot of it is focusing on the systems and the trustworthiness and the measurement, and then just the people's involvement on measuring the decisions and the approach that it's taking.
Yeah, I haven't heard of it, but can you repeat it again?
I was just saying that when I've gone through all of the different areas within the NIST AI risk management framework, the big focus is on the trustworthiness of the AI system and the policies and the risk review of all of those areas that you're dealing with. So it seems to be very similar and very strict on the risk mitigation and understanding of the system itself.
Yeah, and therefore this presentation, because I think the privacy processes in which you define the risks and in risk assessments, you can cover this.
Okay.
Yeah. Here you see some requirements that have to be met if you have a high-risk AI system. So, for example, if you want to use data of your customers, which involves credit scoring, now it's defined under the AI Act that it's a high risk, because you can, if you process credit data, it can have an impact on the individual. Either the individual get a credit or a loan or not. So it can be very impactful. Therefore, it's a high risk. And then, depending on the situation, all of these must be implemented. So technical documentation, you have to register it as needs to be a human in the loop, etc., etc. I see Adam.
We have Adam's name. Adam, yes.
What do you think, or how are companies who use AI to do all of these handled? To generate all their documentation and identification and classification.
I don't quite understand what you mean.
So is it possible for people to use AI systems to do a lot of their risk management and definition?
Yeah, I've never heard of it, but I think it can be, yes.
It's absolutely being done here in the US, I can tell you that.
Yeah. Yeah.
Now, just to add on this one, in Europe and I know in the Netherlands, there are all organizations already diving into that one.
Yeah.
But I'm not sure on what stage it is. Is it just checking out, is it possible, and what can we do, and where it's going? Because a lot of organizations still are holding back on introducing it big time, because we need to understand what Rowana is explaining, right, about the whole AI Act. What does it involve? So we are playing with, let's say in Europe we are playing until a certain amount, but officially it's not. There are not a lot of companies doing it big time.
No. Not yet.
But it's happening here as well, Adam, just like in I think everywhere.
Yeah. I think we had a talk about 3 weeks ago where the guy was actually presenting the fact that we could use AI to check a lot of everything from cyber attacks to all these things.
Are there any law cases in progress against anyone for anything that they've been doing on AI, or is it?
Oh, I can tell you both here in the U.S. and worldwide, there are a plethora of lawsuits. A lot around healthcare and decisions that have been made by AI that were erroneous.
Mm-hmm.
And is that the legal consequences or not?
Yep.
They're still going. They're going through the legal system. But I've likened in the sessions that I've spoken at here in the U.S., what I've likened them to, and many of you may have to do a little bit of research. Back in the mid 90s and up to the early 2000s, we had a lot of HMOs here in the States, health maintenance organizations, right? And what they had was they had non-medical personnel, clerical personnel, making the decisions on whether a treatment or was needed because they were trying to control their costs. And the lawsuits that ensued from that virtually eliminated HMOs. I think we have like 2 major HMOs left in the country at this point.
Yeah. So, I mean, really what I'm trying to understand is there sufficient legal repercussion that people are saying, hold on a second, I better think about this? Is there? Okay.
Yeah. I mean, as Adam has pointed out, even with they going after the LLMs for harvesting data that's not there. So there's quite a few of these things on the go.
Mm-hmm.
There's also legal challenges to the use of AI in creation of things. So right now in the U.S., anything that is created, say artwork, that is created, even in part with an AI system, cannot be copyrighted.
Yeah, that is indeed intellectual property law. How you say it? It's really a hot topic regarding AI, and I think there are more lawsuits coming.
Yeah, it's what I call law of unintended consequences. People don't think about the potential, what could happen. They don't think about the negative, what could happen down the road if something didn't quite go right.
Exactly, and that's why the AI Act now defines that someone needs to be accountable for. You have a specific role, you are responsible, and also responsible to train your employees who work with AI, and also demonstrate that you were communicating or your data is processed via AI.
Yeah. I mean, I'll just point out what I'm sure you probably all of you are aware. Look back at the initial release of every single new model, and what an epic failure that initial release of that version was. even up to the most recent one, which was the release of Grok, the new release of Grok. Complete failure. They had to pull it, rework it, and then re-release it.
Sorry, guys, I just want to check. Rowana, are you okay with the questions? Is there some more content you'd like to get through?
Yes, I have more content, so yes, a little bit more.
Okay, so okay, thank you.
Yeah, I like to dive into the more practical side, and maybe more interesting for you as well as how you cover ethics. And yeah, I do it high over, but for my practical experience, yeah, you need to make sure that a human is in control or in the loop or in the process covered. Yeah, I've said it all before, but the AI system must be technical, robust, and safe. You must, yeah, of course, that's the red line of this presentation, but you need to make sure that privacy and data governance is covered. Transparency is also important. I've mentioned it many times, but it's very important that someone knows that they are talking to an AI system and what the risks are. Yeah, and accountability, all these principles you have to keep in mind when using AI and when you want to implement a process regarding AI. And here I've mentioned some practical examples of how you can implement it and cover it. It's by performing data privacy impact assessment, because most of the time an AI system processes personal data. So you need to make sure what kind of data is processed, what is the purpose of it, what are the retention periods, is it secure to use it, and the GDPR principles that I've mentioned. And then you can assess, okay, if this is under the GDPR allowed, can I then use it for AI purposes? Can I use then AI itself? Because under the GDPR, you can only process it for specific and explicit reasons and purposes, but you cannot process the data further if it's incompatible with those purposes. So if I want to process personal data, in the example in the beginning of my slide and my presentation is that I want, as a startup, I want to use personal data, the postal address of my customers, because I want to send my product to them. I want to send my product to the customers, otherwise I cannot sell anything. The second purpose is now I want to use the same postal address to train my AI. Then is the question, is it allowed or not? And it's only allowed if I have a legal ground. That's also what I've discussed before. And it's only allowed if I do not have consent, because if I want to sell my products in the beginning of the phase that I'm in contact with my customer, they do not know, and I didn't know before, that I use it for AI purposes. So there's no consent, there's no legal ground it's not necessary for the performance of the contract. So I have a different legal ground if I want to use a postal address for AI. And then I need to assess, which legal ground I have. And the only one could be is legitimate interest. Do I have a legitimate interest? What is my interest to do it via AI? Now, I want to improve my service. It could be a motivation, a purpose, and therefore I need to check, okay, what is my legitimate interest? And I have to do an assessment. What is my purpose? Is it necessary to use AI? And the balancing test. That means what is my interest and what is that of the customer? Does it impact the customer or not? Does my interest prevail or not? That is the assessment that you need to do. And if it's a positive one, so let's say my interest is prevailing and it's more important than it isn't impactful for the customer, then you can use it for AI purposes. I'm almost at the end of my presentation, so some tips and tricks. Yeah, always perform privacy impact assessments or some kind of assessment to identify and implement the measures to regarding the data and address AI-specific risks. Perform the legitimate interest assessment. Yeah, and secure the fundamental rights, that you are transparent and make sure that you are accountable. And often in large companies, it's a multidisciplinary approach. Include IT for connecting the AI system to in your existing landscape, IT landscape. Include legal if you want to have legal agreements with about your AI system and your intellectual property, for example. Or if you want to buy an AI system from another company, make sure that the conditions are fair. Include compliance, data management, etc., etc. And then a balance between innovation and the business environment. I think yes, the last my last slide is already the summary of what I've just discussed. So there are a lot of similarities between the GDPR and the AI Act. It's about data protection and security, transparency, a lot of accountability. The roles and responsibilities are similar. Someone needs to be accountable and is responsible. The documentation, under both laws, you need to document everything that you do regarding AI, regarding the processing of personal data. And both of the laws, stated that there are high fines if you are violating the law. And in my opinion, the challenge will be AI literacy. So covering that all your employees are trained who work with AI, and that the rights of individuals are covered properly. So you need to implement it in your process. And the challenge, I think you all know, under the GDPR is data minimalization. So you only need to use the data that you need, and you can only use that. But under the AI Act, you had a lot of data sets, and I think more data, the more is better. And documentation and monitoring of this all. Like I just said, there's a lot of documentation required under the AI Act. And requires a lot of administration.
Great. Rowana, I'm assuming you finished. Is that correct? Okay. So we've got a few questions. William's hand is up. William, anything?
Yes. So, Rowana, when we talk about AI systems, we tend to just think of it as a bit of software that has no memory whatsoever of what it just did. In other words, I use the data, I've now learned certain patterns, I throw away all the data, I remember none of the data whatsoever, but I'm now a more intelligent piece of software, right?
Yeah.
So is that in fact true, or do I, as an AI tool, actually have a bit of residual memory of the things that I used to learn something? And I'm thinking specifically around things like when we speak to human beings and we say, yes, you can have a look at it, well, they've got to sign a non-disclosure agreement, right? We don't have anything, to the best of our knowledge, in that space with an AI to say, by the way, you can't remember this any longer. I don't know how that memory part works with these AI tools.
Good question. Let me think about that. I think I have to think about that.
Okay, that's cool. That's fine. Maybe, Adam, you run into that problem.
I mean, William, the other thing that one understands is with the Gen AI and with your communication, part of the process is there's actually extraction of the tacit knowledge of people and storing of that tacit knowledge engagement. So certainly when I've seen a few people say that after a while of talking to ChatGPT or whatever it is, someone said, well, can you tell me what you know about me? Okay, and sometimes the answers are pretty revealing.
You just go ask your 5-year-old child; they'll give you the truth.
I'll have to try that the next time I decide to use a chat bot. That's something I always raise, Howard, is personally, I have yet to encounter a satisfactory chat bot.
Right.
They annoy the heck out of me. They've implemented the same thing with voice prompts and voice navigation and stuff. And I avoid that at all costs unless it's just the most simple of things. I view them as nothing more than an interactive FAQ.
It's interesting because I know I use it a lot, and constantly when I talk on a different topic, it says to me, I see that you've also applied this to this term, this thing that you're talking about, and these two topics relate. So it's remembering what I'm engaging with.
I have yet to see that with any chat bot, and I put the challenge to many companies: show me a chat bot that I find effective. And the ones I've been presented with, I've always been able to tear down.
Sure, but if we look at the ChatGPT, not so much the chatbot, but ChatGPT and Copilot and things like that, I think there's lots of storage that's happening. Okay, there's another question from Andrew. Does the AI Act have the same jurisdiction as GDPR? With GDPR, if you're a South African company and an EU citizen transact with you, you have to comply with GDPR. Does the AI Act have similar reach, affecting residents in the EU or all EU citizens, or is it bound by geography?
No, it's not bound by geography. And I'll jump into my, it is applicable in every EU member state, and also if the AI activity takes place into South Africa and from, and the output is from EU citizens. So it has a broader scope.
So basically the same as GDPR, Rowana.
Yeah, basically, yes.
My understanding is from the lawyer that presented some time back, he said, for example,
Howard, we lost you.
Howard is lost.
Howard is lost.
Well, he did freeze in an interesting position, right? We should frame it. Yeah, so
Debbie, can you wake him up?
I find this very interesting, Rowana. Thank you.
Yeah.
One of the other questions, similar to where Howard was going on this, if I'm in South Africa and I design a AI myself, and I then allow it to interact with South African clients in the EU, is that then considered AI because it's going through the AI, at least the networks in the European Union?
Good question. I think I have
to. It's about, so for example, if I've got data that I'm storing in a data center in the US, I can't go and move personal information into that data center because then it's crossing boundaries, right? Yeah. To what extent do we have the same thing with artificial intelligence crossing boundaries? Is there any boundary limit to this or not really?
No, not as clear as in the GDPR. Then under the GDPR, you must have, there are mechanisms such as a standard contractual clauses to transfer the data. But it's regarding AI, I don't think there is.
So if my AI bot transfers personal information across boundaries, that's a gray area.
Not per se, depending on what your AI bot does and process, then you are coming, depending on
so for example, level. India, right? India has a lot of bots running the networks and all the rest of it. They're collecting personal information all the time. Is that a breach of GDPR, or is it because it's using it on a bot, it's not applicable?
No, if it involves...
Maybe, yeah. Rowana, I work for a recruitment company who were scraping completely LinkedIn bot style, right, to get all the information.
Yeah.
And they were bound to delete all the data from what they were scraping every X amount. I'm not sure what the amount of time was, because they are not allowed, according to GDPR, to use that data for a longer time. So there is some kind of a I would say that if a bot is scraping or transferring personal data, the GDPR rule still applies. You cannot say, oh, it's a bot doing it, so GDPR doesn't have any effect anymore.
Therefore, I started my presentation with the definition of personal data. As long as it's personal data involved, then the GDPR applies, or any regulation that it covers data privacy. But yes, indeed, then the GDPR is applicable as long as you process personal data.
Thank you, that's helpful.
So just a question from my side, when the AI legal person presented a couple of months back, I need to find the actual webinar, but he was saying that the restrictions of AI processing happening outside of GDPR is a lot more restrictive than just GDPR. So they couldn't, as an example, get South Africa to do certain processing on external people that they were not allowed to do. So the restrictions about using anybody around the world to do things on their behalf was also a no-no. It's also not allowed.
It's depending, of course, on the situation, but I cannot transfer per se by now my data to South Africa, for example. No, I need to make sure that I have a legal ground, but also a valid mechanism that is equal as the GDPR, so that my personal data is as equally protected under the GDPR as in another country like South Africa. I think that's what you mean.
A little bit more. So you were saying that, but let's say, for example, in Europe, they're not allowed to do certain processing of foreign customer information, and they say, well, okay, well, why don't we do this processing in a remote country where it doesn't have that restriction about the people that are not EU? So you're saying any processing that cannot be outsourced and then adhere to different rules.
Can I give an example of that?
Yeah, sure.
In the UK, one particular company wanted their service provider to build their Power BI reports. So they then outsourced a company in India, which does not have rights and under GDPR. And they said, we will send you the live data. Will you please build the Power BI reports? But that then was crossing the GDPR boundary. So that is now in the UK to a UK company, the UK company itself sending to its own affiliate. But the problem is that is outside of GDPR rules. the same sort of thing can be applied in terms of AI, where AI is sitting in India.
Yeah.
So that wouldn't be permitted either.
Yeah, like I said, it's under the AI. Yeah, I think it's not. It's a good question. I think I'd like to jump into that later. If can I come back to you with that? But because I think it's similar.
Okay.
It shouldn't be allowed.
Adam, I see your hands up. Sorry, Adam, you're on mute.
Yep, sorry, I was typing in the chat here, and I'm on my phone, so
multi-failing.
Can't multitask on things. I will say that one of the things that was listed, the one thing that I really admire about the EU GDPR and the AI Act is that the penalties are actually what's what I'm looking for? They are a deterrent in themselves because they are so severe.
Indeed.
It makes a lot of companies think twice about doing things. Whereas, unfortunately, again, here in the US, I've lost track of the number of companies that go, hey, regulatory fines, just chalk it up, cost of doing business. I don't care.
Yes, indeed.
And Adam, it's interesting you say that because Papaya, which is the South African privacy, they've actually instituted criminal judgment. So they've taken it further now to actually take you to court and you'll be processed on a criminal basis.
I'd love. How is that defined? I'm curious because that was new to me.
I'll send you some of the details. That was one of the big things that Papaya went a little bit further than GDPR.
What the process is and who actually is affected, right? Are the executives or the CX.
So basically the CEO is finally responsible, but there's a whole lot of institution of the DPO and things like that. But if that's not done, it's the CEO that can be taken to court and to be prosecuted on a criminal basis.
I would, while I would love to see that here in the US, I highly doubt that anyone will ever agree to it. You know, that's on the level of Congress deciding to not give themselves raises or limiting their terms.
Right. Okay.
In terms of storage of data, we understand data centers have their jurisdictions, and it's easy enough to say, well, where are you storing my data, right? We also know that there's a certain amount of processing of data. How much processing of AI, etc., is happening on satellites and things that are outside of the normal jurisdiction that we think about? And how does that play in? Because it's a piece of software, right? It's not got the data stored in any place. Is it itself moving around the internet or whatever the case is? Does it have a requirement? Oh, I'm in this area, I can no longer work with that data. I mean, we are asking it to be a little bit honest, right? I don't think we've got an answer to that. It's just an observation.
Any comments?
I think it's a good it's a good one, William. Good observation.
Yeah, there's so much we can't see and we do not know. But yeah.
Rowana, the other thing that you spoke on the impact assessments, and you listed a privacy impact assessment, but you never really referred to an ethical impact assessment like ODI has on your last set. Yeah, there's risk mitigation, you got data privacy, and but you never really referred to an ethical impact assessment.
No, yeah, that is also part that needs to be covered. And it's in the evaluation in the data privacy impact assessment. Yeah, that's what I currently do right now. It's just the ethics is a new part. And and I'll take this all into consideration from human control, and is it in the loop, or what does it is it non-discriminatory? Is it the data set diverse? Yeah, all of those things are fairly new. And yes, there are impact assessments, but I currently now try to implement it in the at the same time in the privacy impact assessment.
Okay.
And yes, there are several. I think you can Google it, and then you can find assessment templates, etc. But
yes,
yeah, there is no one like the privacy impact assessment. There is no centralized assessment. Yeah, no, unfortunately.
And there's a question from Andrew. He said, if I train an unsupervised AI model on my customer base, and in terms of GDPR, if someone requests that I delete their information, do I need to retrain the model and prove that their data was, we can't prove that the data was used?
If you have to retrain it, I'm not sure, but yeah, you have to delete the data if you receive that request, and yeah, that is if you can do that, you need to do that. But depending on it's also fairly new. How do we deal with this? How do we deal the data of the person involved if it's part of the data set? Is the data set then still valid? Or a lot of questions are popping into my mind.
It's a bit like deleting the teacher because they happen to teach the child the wrong thing, right?
Yeah, it could be.
I would think that you don't really need to retrain the model from a point of view of you first of all will work out the features that are appropriate within the model, and you'll typically not find that individual's features. I mean, it's basically it's DID, the person itself has gone from that model. They wouldn't be training it on the individual.
I think it's interesting. I just popped a question into ChatGPT and only gave the summary, but ChatGPT isn't also, of course, kind of whatever, but they say basically, and I think that's it, right? You don't have to retrain your model immediately, and as long as you make sure that you the data you used before, which people say I want to be removed, is actually removed for next iteration, whatever.
That is good.
Yeah, I think it's fun to have a couple of those questions were popping up. Is also just put them in ChatGPT and see what their answer is. I think that is kind of interesting to see what they are going to give on their own information.
Right.
It's what they're good at.
Oh yes.
I think one aspect of well-trained models is that there is normally no association with individuals. It's either anonymized or it's aggregate.
Yeah.
Right. So individuals' data is still there, but cannot be tied back to them as an individual.
It's the features, that feature of the individual has been removed. There are high-level aggregations that it contributes to, but the individual is no longer there.
Exactly. And you do that with the data that you're feeding into your model to do the training.
Right.
And the same for synthetic, you know, you're going to base your synthetic generation on all of that as well.
Yeah. On this. Great. Rowana, I'd like to, there's one question from Christina. Yes, Christina.
Hi, everybody. So I'd asked the question about the models being currently in use, but then I think about, like, I created a model that had customer data in it, and then I used that model to train a new model. And so if somebody requests that their information be removed, but their information was part of the model, the older model, does that matter? Does it still have to be, or is that just, it's not being used, it was used as a training, it's inactive?
Well, again, with respect to kind of what I was just saying, Christina, did you include any personal identification in that in data that
like
could
the
be tied
ID number or the name or the email?
So that is definitely an interesting question, because we were talking about this yesterday in terms of sensitive, conditionally sensitive data. So maybe the data that went into the model was not PII. However, there could be a data point in the model that connected with another data point that would cause it to create a PII. And one of the examples was using an address, right? So if I do have maybe the zip code, the city, the state, maybe I have the zip code all the way down to the lowest level that you can use in the United States, but then I marry that with something else within that data set, does it create potential PII? And so that is something else that's come up, because we are in the process of trying to understand how data can be conditionally sensitive when put with something else, even if it's anonymized, right? So I could have an entire anonymized set, but I add one data point to it, and all of a sudden you may be able to pick out a person from it.
Yeah.
Yeah, and that's what I would say. That's in the planning of it, in the architecture of it, and looking for those potential data connections.
Yes.
Which, depending on the volume of data you're working with, that it can be a challenge, but you still got your classifications of what those are.
Right.
But that needs to be taken into account.
Yeah. So it's basically the algorithm of re-identification. Can the individual be re-identified with the data that you have?
Interesting.
Because I mean, that's especially when you're talking about medical data, because I think some of the greatest advances have been around medical data and diagnosis. I'm still a little bit on the edge, but imaging, phenomenal advances in imaging, which is still reviewed by physicians, afterwards for their assessment on it. But obviously, that here in the U.S., that's all HIPAA. That's all very tightly controlled.
So, I mean, I just asked just a normal thing on Google. Can you let me know who are autistic people in the UK? Autism is one of those protected things, right? Well, it was quite happy to give me everybody that's publicly known to be. And I think that's part of our problem, right? If this is a person who has publicly expressed something, then it becomes public information for which, they are happy that it's out there. Unless they've been on some tabloid or something or another, and they haven't really given their approval, and it's just part of history. So there's another hair to split as well, right?
Well, William, this comes to this point of the right to be forgotten. So there are cases against Google where you can request that they do not any show that any longer. So Lucy could go to Google and say, I do not want you to return these results anymore.
Yeah, it's interesting.
Yeah.
Of course, the chatbot doesn't know any difference about that, right? So
but the chatbot and the chat GPT, they are geared, or they're getting more and more trained not to return any personal information. Now, initially it was free for all, but lately, if you ask, I mean, I remember asking Copilot, and it gave address and people's names and things like that.
Yeah.
So it's just getting better. I mean, it was bad, but I think they're slowly but surely buttoning that down.
Used to be the Wild West. We're getting a little tamer.
Yeah.
That example adds yet another twist with the current LLMs, is the inherent bias in the training data. So you may ask for personal data on one individual, and it will say, I'm sorry, I'm not permitted to do that. But ask it on another individual, and it will freely give you that information.
Yeah, I think I found different LLMs to be trained differently. So especially on things like the Meta one that I've tested, it says any name, anything. I can't divulge the details. So some of them are working quite well, Adam, and some of them leak. I've seen a big change on that in terms of locking that down. But I mean.
I also hear, Howard, that listening in from all the connections and the reactions and responses, I hear that you need to organize a new session for this one.
Yes.
Maybe not so much.
You talk for hours on this.
Yeah, but
indeed.
There might be.
Yeah, I had to prepare this on invitation of Remco. I went to Iceland and I spoke about the same topic. Only difference was that it was in 20 minutes. But
right.
Like you said, Andrew, I can talk about it for each aspect that I discussed today. Like the ethics questions of Howard, the ethics assessment. You can talk about it. I can make a webinar about it. It's each topic. It's so much, and it's complex, but it's also a lot
Debbie, I hear follow up. You can plan.
Yes, most definitely. We can
I hear you and second you, right?
I would toss in along with ethics, because that's one of my areas of focus, is along with bias.
Yes. Yep. Yeah, and I'm approaching it from a really high level that I do not have a data background or a technical background. I have a legal background, and that is it is new, and it's all and it's super interesting, but ethics and bias, and you can talk about it for hours.
I think you're but then again, I'm kind of maybe having some prejudice on this one, but I think your angle, your background is a benefit for us data people.
Absolutely.
To make us think in a different angle.
Good, that's good to hear.
Sure.
Absolutely. I will give a quick anecdote. With my background in regulatory and compliance, I bring that to my data roles, and my roles as product managers, product owners, and stuff. Mm-hmm. And other executives, they're astonished by it, because it's stuff that they've never even considered.
No.
And I'm like, hey, look, I'm not an auditor, but I know what auditors want, and I know what the government is going to want. Exactly. So you need to factor this stuff in.
Mm-hmm. Indeed. Yeah.
So Rowana, totally. I think we can all say that you are now an honorary data management person, right?
Thank you. So good to hear.
William, we may question your accuracy, but
indeed,
I like your thinking. Guys, thank you very much.
Thank you, Howard. Thank you, team. as always,
Thanks,
Howard.
Rowana, I'm sure we'll have you back. I really appreciate your presentation. It was great. Thank you very much.
Thanks so much for this invitation. Yeah.
Rowana, I think what Howard's also saying by that is you're welcome to join in on these webinars and listen.